This is Stephen Leskin, and it is another Thursday night at about 6 o'clock, and there are lots of people signed up for this webinar, so let's get started. My name is Stephen Leskin. I am a divorce attorney in Portland. I'm also a mediator. You can find my website at onedaydivorcemediation.com. I do these seminars, webinars every other week, and my goal is to provide people going through divorce with accurate information so they can make better decisions, have less stress, and generally, hopefully, find the process a little bit more understandable. Like I said, I've been an attorney in Portland for almost 30 years. Last 10 years or so, maybe a little longer, I've been doing nothing but divorce. So let's get started. Um, the agenda tonight is meet Stephen Leskin. The bigger topic is alternatives to divorce litigation, and so we're going to be looking at a couple of alternatives to going to court. There are actually four or so other ways to get a divorce done, other than just going to court and having a judge decide and then doing a judgment. And so we're going to focus on what those other um, processes are to get to the same result. Some are going to be better than going to court. Some aren't going to be appropriate for your situation. And hopefully by the end of the talk, people have a pretty good idea of um, what's available. All right, so we're going to do meet Stephen Luskin, of course. What is litigation? We'll come next. We'll talk about what a litigated case looks like. We'll talk about what an uncontested divorce is. I get a lot of calls from people like, we want to do an uncontested divorce. We agree on everything. And then you start digging down a little bit with the caller, and it turns out that it's mostly wishful thinking. And I'll get into my views about when an uncontested divorce is um, is appropriate and what a genuine uncontested divorce is. We'll then talk about mediation, arbitration, and then hybrid mediation and arbitration. So that's the game plan for tonight. Let's keep moving along. All right, so here is meet Stephen Leskin. I say that was like thrilled, happy to meet myself, I guess. In any event, I've been an attorney, a media. That was a really lame comment. I just need to acknowledge that. So I've been an attorney uh, in Oregon since 1992. My practice areas have evolved over the years. I've done personal injury, Social Security, disability, commercial litigation, and for the last, I don't know, 5, 10 years, I've been doing mostly and exclusively divorce litigation and arbitration and mediation. So I really, at this point, more of a mediator than a litigator, but I still take on a fair amount of litigated cases. My website can be found at www.leskinlaw.com. I can be contacted at the email address on the screen, and certainly happy to get phone calls at this number. I don't take questions during the webinar. I find that they just break my concentration and the flow of the comments, my comments. But I am happy to take uh, email or phone calls. So if there's something that you have some questions about, please, give me a call. Happy to engage with people about the issues in your case privately. All right, so let's get into it. What is litigation? So litigation, we all, or probably most of us know that litigation is people going to court to get the court to decide their dispute. So litigation, obviously, like a car accident case or a commercial dispute or a criminal case, uh, that all of those using the court system to resolve a conflict is litigation. And litigation involves uh, filing a complaint or petition with the court, the other side responding. There's a process of discovering what information both sides have, the exchange of information, that's called discovery, and then Usually there's a negotiation process. People just don't go to court. There's usually either a formal mediation process or arbitration process. And then if that fails, then the case will go before a judge. And then a trial is both sides putting on their competing evidence to convince the court of the rightness of their case. Obviously, trials more involved. My last video was I spent an hour talking about just what a divorce trial looks like. If you're interested in that, just go back and it's on the website. You can go back and take a look if you really want to get into what a trial uh, looks like, what the format is, and how evidence is presented, and all of that stuff. Um, the goal of litigation, and in fact, the goal of all of the processes I'm going to discuss, is to come up with a judgment. The final result of any court proceeding, is a general judgment. It may be called different things in different states, but in Oregon, a divorce judgment formally is called a general judgment of dissolution. If there was no marriage and there's only kids, it's called a general judgment of custody. And then uh, whatever process you use, the whole point of litigation or mediation or arbitration is to come up with a judgment. And uh, that, from a lawyer's perspective, that is the bottom line. And how you get to the judgment uh, matters, but um, it may matter a lot. But regardless of what process you do, ultimately you're going to file a judgment with the court. If you litigate and you put on your case, you put on your case, and a judge uh, takes the case and makes a decision on it. That is called the general judgment dissolution. I apologize for the people who are live. There was somebody knocking at my door. So the the other two types of judgment and are important because they may not necessarily involve a court process. So, for example, you can go to private arbitration, which we'll talk about. You can go and resolve your case through mediation, which we're going to talk about. And those become judgments by stipulation, meaning, or you could settle your case, not go before a judge, and to settle the case directly. All of those are judgments by stipulation, right? Because the parties have agreed to them. Uh, the third type of judgment would be a default judgment where a petition or a complaint is filed, somebody doesn't show up, and then 30 days later, the other party moves by default. We're not covering that tonight. What we're covering in all cases uh, is a general judgment of dissolution or a general judgment of dissolution by stipulation. And so when you mediate and you come to an agreement, it's a stipulated. When you arbitrate and come to an agreement, it's a stipulation. And using the third hybrid mediation binding arbitration method, that's also a stipulated, uh, a general judgment of dissolution by stipulation. How to get to court. Um, if you are in the litigation realm, if you are litigating your case, you've filed a petition and the other side's filed a response, that's how you get to court. You open the process by filing a petition. Uh, with the other processes that we will talk about, you may not actually start with filing a lawsuit, but with litigation is always initiated by either a petition of dissolution or in other types of cases by a complaint. So the way you get into court is by filing in divorce court is by filing the petition for dissolution. We just talked about the court process just a little bit, and um, what I will say about the court process uh, is that I'm going to talk about this under downsides of this. This is the downsides of litigation. Is that it can be extraordinarily expensive. It's not unusual to spend in a custody case $20,000 for a day in court. That is not unusual. Um, so you've got the expense. It is stressful. You very well may not get what you think you are owed. Uh, and uh, once you surrender your decision making uh, to a third party, i.e., a judge, there's usually less buy-in. So usually one party, the party who didn't get what they wanted, is always going to be resistant to the judgment. So litigation is appropriate when there's a lot of circumstances under which litigation is 100% appropriate. Uh, but uh, for many people, it's not the best way forward for those reasons. It's stressful. It can take a year to get to court. It's expensive. There's risks that you have to consider that you will not prevail. So um, that's like that's the downsides of litigation. Going to trial, you can spend a day, it depends on the case, of course. You can spend a day in court. Uh, nobody thinks that going to court is pleasant. It is in fact stressful. It's an ugly day for many people. It's probably one of the worst days of their lives. Uh, it just it's just not a court is just it's just difficult. And um, uh, with an unnecessarily uncertain outcome. And I say that because if there was a certain outcome, a case would settle, right? Most cases settle because the parties come to uh, a similar agreement about what is right under the law. When you can't, then you go to court. And so both parties are evaluating that they have the greater chance of prevailing before a judge. And so that just in and of itself necessarily creates a stressful uh, situation and creates a situation where if one when one party loses, that party does not have buy-in to the um, judgment and is more likely to resist and require more litigation in the future. Post-trial, regardless of how you get there, uh, post-trial means continued litigation after the judgment. And so a party could be ordered to pay spousal support, for example, and not pay. And then you're required to go back to court and get a court order that that person needs to pay spousal support or child support, or hand over the keys to a car, or buy life insurance. I mean, there are a myriad of things that a court can order that somebody won't comply with. And so that um, will require additional court time, more lawyer fees, more stress, more time away from work. And so those are post-trial matters that will come up. I think that post-trial matters are less likely where there's mediation because through the mediation process, people have buy-in to the result. They've agreed to something and they're more likely to comply with something they've agreed with than what's been imposed on them. So post-trial issues are also something to uh, uh, keep in the back of your mind. The other part of the downsides is that even if you go to trial and you prevail, the other side has the option to take the case to the Court of Appeals. So you've spent a year litigating, maybe you've spent 20 or $25,000 and you've gotten a result that you're happy with. The other side may say, well, we'll still see you in court again. And then that's another year. Uh, Unbelievably, um, cases that go to the appeals court are even more expensive than the cases that go before trial, before a judge at a trial, because of the specialized nature of appeals work. They just tend to be very, very expensive endeavors. So that's what litigation is. That's what litigation is all about. I am just going to editorialize here for a minute and uh, um, like express like a point of view. The courts manifest the laws, or actually more accurately, bureaucracies manifest laws, meaning uh, institutions grow up to enforce laws or implement laws, right? So you have a divorce law, and the courts interpret that, and that's what they do. And that's what their whole mission is. So courts are really, really good at enforcing rights, and I'm going to say usually. Um, they are not really good at like being sensitive to people. Like individual judges maybe, but as an institution, courts don't care about your personal needs in most cases. Um, so there's no concern for something like customer service. There's no concern for what works for the clients. Once you get a court date, the court will assign a court date. The court doesn't care if you can't make it. You will be there. The courts don't um, like you have to be there, right? You can't like not show up. So courts are designed to enforce rights, and that's what they do. So it's not necessarily like if you think about it, it's not like necessarily the most conducive uh, way to end an intimate relationship that's no longer works for a party, right? There are other ways to do that that will still get you to a general judgment of dissolution, which is what's required to end the marriage by law. But the court process itself is designed to uh, enforce rights, not um, not see that people, have a good day or a better life or anything like that. Courts are there to bring about the law as it's written by the legislature, and almost everything else is tertiary. So let's move on from litigation. Uh, the uncontested divorce. Okay, so uh, an uncontested divorce is where both spouses agree on everything, and there's not going to be any meaningful negotiation about what goes into the general judgment of dissolution. There may be some like minor tweaks, but in general, the parties agree on everything. And so, in my view, an uncontested divorce is appropriate where the marriage is really simple. The parties need the divorce to get on their way. They don't own a house, they don't have kids, there's not complicated retirement accounts or investments. Those are all things, to my mind, which disqualify people from an uncontested divorce. Once you start drilling down into all of the dozens of details that you need to decide about like how a home is going to be divided in a divorce, it's inevitable that there's going to be dispute. And once there's dispute, it's no longer uncontested. So, or if there's kids, with kids, you have to develop a parenting plan, decide who's got have custody or how custody is going to be decided. You're going to have to decide all of the factors that go into making a child support calculation. So, um, those are all things that require negotiation and potentially disagreement. So, in my view, the only time an uncontested divorce is truly appropriate is when the divorce is simple, like the parties just need the divorce to get on with their lives, or um, uh, that's pretty much like if there's a like if there's like division of property or division of debt, people can do that on their own. Like, I'm going to take this car, you're going to take this property from the house, or we're already living together and all the property's already been divided. Like then it's uncontested divorce is certainly appropriate and um, is fine. But it's once like you start adding the complexity to it, like dividing complicated retirement accounts or um, a house or kids, that complexity negates or will negate uh, the ability to really have a truly uncontested divorce. Um, the advantages of an uncontested divorce is that they can be done quickly and reasonably inexpensively. The way I do an uncontested divorce is, and for some reason, I have a reputation for doing them, and a lot of them come to my office. And my representation agreement says that once an attorney on the other side is hired, it's no longer an uncontested divorce and needs to be treated as an hourly contested matter. Um, uh, so the way I handle it is, I send out questionnaires to people. They come back. I prepare the documents. It's like that simple. My and just to give people some idea of like the costs involved, my fees for doing an uncontested divorce, I'd usually do it on a flat fee and charge $1,000 to $2,000 plus the filing fee. I have heard of attorneys in Portland charging $8,000 for uncontested divorce. If you're spending that much money on it, it's no longer really uncontested. In any event, there's no world in which an uncontested divorce with, without kids or without, um, you know, a house should cost that much. Generally, my view is that it should cost 1,000, 15, $2,000. Uh, if it's less than that, I would question the competency of the attorney. Uh, it's just hard to do in time uh, that would make it worthwhile for the attorney for amounts less than that. Mm. Excuse me. That's just maybe there are attorneys who have figured out how to do it better than I have or faster than I have. But generally, 1,000, 15, 2,000 is a is in my view is a fair amount for what people need. I would also add that if the divorce is truly uncontested, the property's already been split, there's no debt, or the debt has already been split, there's no kids, then an uncontested divorce can also take the form of both parties downloading the court-generated forms, filling them out, and then signing them, and then filing them with the court. That's also an uncontested divorce. If it's an uncontested divorce, you may not need to, you may want the convenience and security of hiring a lawyer, but if it's just truly, we need the divorce to be on our way, then people can certainly do that on their own. I don't, when it gets into like having kids, I still get confused over stuff, and I've been doing this for 30 years. So, um, the state of Oregon court forms have gotten better over the years, and I really don't have like any like objection to people doing it themselves if it's an appropriate case. So the advantages of an uncontested divorce are simplicity, speed, lack of conflict, lower expense. So if you and your spouse can get there, um, or have a simple enough marital estate, an uncontested divorce is certainly appropriate. And just really what it means is that both parties are filling out the general judgment of dissolution together and signing it together and filing it with the court. Um, uh, so bottom line, that's what it is. That is that you're filling out the paperwork on your own, or the attorney's filling it out. You're both signing it, and it gets filed with the court. So let's talk about mediation. Over the last several years, my practice has been growing as I've been growing my mediation practice. And I do more and more mediation now. I really am on a crusade to keep people out of the courts. From the discussion of litigation a couple moments ago, I just don't believe that that's generally in people's best interests. There are cases where litigation is appropriate, where there's maybe like huge, like one of the partners has access to huge amounts of money, and excuse me, um, uh, or where there's been domestic violence or something along those lines, or there's complicated matters that require a court to tease them out in an adversarial process. There are certainly some cases where that is appropriate. But I think for 90% of divorcing couples, um, litigation is not necessary. It's certainly not required and is a detriment in the end because of all the stress it causes, because of all the stress on the kids and people's mental health and the expense. It's not really the best way forward. Mediation, there are plenty of people in attorneys and others who do mediation in Portland and in Oregon. Mediation is the process of talking to your spouse or adversary here, but it's the process of talking to your spouse through a neutral third party to attempt to achieve a solution or resolution. So, what mediation often looks like is the parties, whether it's a divorce or not, is the parties sitting in an office. Maybe they're sitting at a table together with the mediator and going back and forth and saying, this doesn't work for me, but this would. And the other party saying, well, that might work for me if we do this or that. And so it's the process of going back and forth uh, until you achieve a solution. Mediation is necessarily a voluntary process. You cannot compel somebody to come to an agreement in a mediation. It's just the nature of mediation is that it is always 100% voluntary. Court mediation, so if you filed and you're in the court may require you to mediate. Uh, in family law court, each of the counties has different requirements for mediation. Some counties you can mediate the whole um, uh, divorce. Other counties it's only pertaining to the children. Uh, but regardless, mediate, and so you have to show up to the mediation, but you are not required to achieve a solution. You still always have, when you go through mediation, you always have the option of going back into court to get a judge's decision. Uh, the upsides of mediation are uh, there are many, I should say it like this, there are many upsides of mediation. It's a voluntary process. People have to choose to be there. Uh, the process is consensual, uh, meaning that there will be buy-in to the result later because it's not imposed by a neutral third party who the parties don't know. So, uh, and it gives people ownership and a chance to craft a specific solution that works for the both of them, for both people. So, mediation um, is advantageous because of it's private, it's consensual, and it has buy-in. And um, uh, generally, mediation is private. Not generally. I misspoke. Mediation is always private, right? The result, what goes on in mediation, stays within the mediation. And one of the tenets of mediation is that what happens remains confidential to the mediation. Uh, and uh, um, regardless of whether that's in the courts or through private mediation. There are many retired judges in the Portland area and also throughout Oregon that have been doing uh, family law for years, and they will act as mediators. Uh, those they tend to be expensive. It's not a solution that's available to everybody because of the expense. But people, when they privately mediate, that means that they're hiring either a lawyer who's been around for a long time and knows the law, or a retired family law judge. And there are many really, truly outstanding judges who are retired who are now doing private mediations in the Portland area. Um, I tend not to do it, even when I litigate. I tend not to hire them just because of the expense. Um, but their advantage is that they can look at a case and say, I think this is what the court is going to do, and that usually carries a lot of weight with people, particularly if one of the parties is, you know, wed to a position that is probably untenable. The downside of mediation is that you can spend uh, hours and hours and hours at hundreds of dollars an hour and not come to an agreement. So you can do private mediation, and at the end of the day, you have nothing to show for it. And so um, mediation is that is like one of the, to my mind, is one of the significant downsides of mediations. You could spend all this money and spend all this time preparing and going through mediation and still not have an agreement at the end. Like I said a little earlier, divorce courts in Oregon required divorcing spouses to mediate, but not come to an agreement. So you can expect at some point to have a court-sponsored mediation. The courts don't usually charge for that. Some of the courts charge, a small amount for the use of the court's minimum mediators. But many times the mediators through the court process are very good, and it's a good way to get an agreement on some of the issues on the case. Next, the next process we'll look at as an alternative to litigation is arbitration. And arbitration is an alternative court process, uh, right? So it takes place outside of the courtroom. Uh, Arbitrations are always private. They're done usually in a lawyer's office. Both spouses choose the arbitrator. The courts don't in private arbitration. The spouses choose the arbitrator. Usually, the attorneys will talk and will have somebody in mind who they think will be fair and neutral and impartial. Uh, Arbitration can be binding or not, and so in a binding arbitration, you go through a court process, a process similar to a trial. And at the end of the day, whatever the arbitrator decides, that's the outcome, right? So it's binding on people. Uh, the rules of evidence are generally relaxed. Usually, when lawyers are involved in arbitration, there's an agreement over the rules of evidence, or there's stipulations ahead of time over which evidence will be admitted or can be admitted. Uh, the process is less formal, it's less stressful than a court proceeding, but the format does mirror a trial. There will be an opening statement, even going back a little further than that. The parties will provide the arbitrator, just like they would a judge, a hearing memo. They will prep their witnesses the same way. They will draft, they will prepare evidence and exhibits in the same way. There'll be opening statements. There'll be a direct examination of the petitioner, a cross-examination, a direct examination of the respondent, right? The person who's responding to the petition, and a cross-examination, and then maybe rebuttal, and then closing statements, and then the arbitrator will issue a decision. So it's a process that mirrors court, but is less formal and relaxed. For example, I would never, ever, ever, ever like take off my jacket in a courtroom. Like it just doesn't happen. I think early on in my career, I did that once. It was like really like the air conditioning was out in the courtroom, in the courthouse, and I took off my jacket because I was sweating. And the judge sent me a note saying, put your jacket back on. Court is very formal, it's very structured. Uh, Arbitration is not. I could take off my jacket in an arbitration. I could probably even loosen my tie if I wanted to really, get wild. So arbitration is relaxed. It's in an office, uh, not a courtroom. Usually, the arbitrators, are going to try to make people comfortable and have just basic things to make people more at ease. So the proceeding follows the same format of a trial, but is way less formal and uh, intimidating. That's probably the right word, and stressful. Finally, with arbitration, the court documents will be prepared by one of the attorneys. Usually, the arbitrators do not prepare the documents for filing with the court. Sometimes they might, uh, but generally, the general judgment is prepared by one of the attorneys, just as if they've gone to court. Okay, so we're going to get into hybrid mediation and arbitration, and this should really be called hybrid mediation and binding arbitration. This is what I do in my one-day divorce mediation, and I have found this to be a phenomenally successful way to divorce to have people divorce. Um, my in I What a combined hybrid mediation arbitration does is it lets people talk out their issues, come to solutions on their own, and then if they cannot do that, then I step into the role of arbitrator and make binding decisions. And This gives people certainty that the divorce will be concluded on the day that they expect it to be concluded on. It gives people certainty. The way I do it is that it can be done on a flat fee because it's not going to run years into the future. Uh, it's less stressful because it's mediation. There's more buying because it's mediation. But if you can't resolve your disputes, then somebody's going to make those decisions for you. And um, like when I do it, I really, really, really strive to get it right. That in that it reflects what Oregon law is, and will be a pretty good approximation with what happens if you'd gone to court. And of course, that may vary depending on which judge, because there's no absolutes here. But I'm confident that my decisions, are within that ballpark of what any of the courts in Multnomah County or throughout the state would award to people. So I have just found that doing a hybrid mediation, binding arbitration, has all the advantages of mediation, has all the advantages of binding arbitration, without any of the downsides of litigating. And so at the end of the day, uh, this process still results in a stipulated general judgment of dissolution that the parties sign and gets filed with the court. Uh, I have found that through my process in particular, I have found that parties are able to uh, get cases resolved themselves. Many times through my process, parties will call me and say, we've talked this, we understand the process much better now. We are able to resolve this ourselves, in which case we just need you to put together the um, judgment and the other court documents. Uh, but this process just works, and it just works better, and it's better for families. It's better. The less stress, the better it is for the kids. It's better for people's um, future relationship if they're going to have one. If people grow and they change and the marriage is not working anymore, but they're not mad at each other. They're just like, this just it's not working for me. You know, this going to court will destroy what is left of that relationship. It just will. You're each going to pay a lawyer three or four or $500 an hour to bring the other person down, to bring the other person down. That's what you're paying the lawyer for. In my process, the whole focus is on getting solutions that work for people. And so it's not necessarily, there may be hostility, and that's understandable, but the hostility is not baked into the system as it is in an adversarial system like litigation. Uh, and I think most importantly, the parties have ownership of the results because they came to it themselves. They didn't do it. They did it with my help, but they did it on their own. And I'm just there to facilitate. I'm there to throw out some options when people get stuck. I'm there to suggest, you could think about it like this, or we need to also consider this because of potential consequences down the road. Uh, an experienced lawyer is able to anticipate like where friction points are going to develop down the future and then draft a general judgment to anticipate that, right? So the judgment is not only now to end the divorce, it's meant to resolve conflicts into the future. And you can best deal with that um, with through a mediated process. Uh, the court's not concerned with what goes on generally, and sometimes they are, particularly when they're kids. But generally, the courts are not involved with dispute resolution in the future. Whereas mediation, my process there's also a tangible consideration. I guess you really can't have a tangible consideration. Like I don't think a consideration can be tangible, but it's a real concern the way I do it. So um, I don't usually like do infomercials for myself when I do these seminars, but my one-day divorce mediation process has just proved really, really successful for couples. Um, I the years that I've been doing it, I've never had people um, call up and complain about the result, or even I've never gotten a call down the road saying, we have to go to court to enforce the judgment. It just doesn't happen because there's buy-in and parties are working through the issues um, in a constructive manner, in a um, uh, serious, forward-looking environment. So my process just my hybrid mediation and binding arbitration work method for resolving disputes. It just works, and it works really, really well. So that is about it. I'm giving myself the last word. So let's just wrap up with a couple of conclusions. There are multiple viable alternatives to litigating. You do not have to go to court. I am on a crusade to keep you out of court. But even if you don't know that, you do not necessarily have to go to court to get a divorce. There are alternatives to litigating. Um, One of those alternatives is an uncontested divorce, whether you do it through a lawyer or on your own, which is available to people who generally have pretty simple divorces where the property's already been divided or it's easy to divide, where the debt has already been accounted for. Um, it's not like it droned on about earlier. It's really not going to be appropriate where there's complicated financial instruments or retirement accounts or kids or a house that needs to be sold. You really should have, uh, in my view, uh, the money that will cost you is well spent to avoid problems in the future. In fact, uh, for a long time, a part of my practice was I was doing repair work for people who had done the divorce themselves, and they didn't account for things that had to have been accounted for, which would have been resolved had they hired somebody who had done this before. Mediation has many, many good advantages, including ownership of the results and some drawbacks. One of the biggest drawbacks to my mind is that it's not a definitive ending point, that the um, resolution, if there's a resolution, is voluntary. So parties can mediate these, go through the mediation process and still come out without having advanced their cause. Private arbitration, not binding arbitration, private arbitration keeps the dispute private, is similar to a court proceeding, is usually conducted in an attorney's office, and the parties choose the arbitrator. That has the advantage of keeping the dispute private, getting a result. If it's binding, if the parties agree to a binding arbitration, then that will also resolve the dispute in a timely fashion. My process, one day divorce mediation, is a hybrid mediation with binding arbitration, and like which just combines the advantages of mediation with the finality of binding. I think I said that wrong. With the advantages of mediation with the finality of binding arbitration. So you're getting the best of both worlds, including buy-in, finality, and set fee and private mediation. It's not a public event like a trial is. And then lastly, I just want to reiterate the point that like one day divorce mediation is an effective process to divorce and is proven successful with many, 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 many couples over the years through my practice. So thank you for attending. I'm glad that I hope you found that. I'm glad that you're here. I hope you found that uh, um, more informative than entertaining. And please feel free to contact me if you have questions about the content of tonight's webinar. Thanks. Thanks for attending.